So a signing statement is an official legal document that a president issues on the day he signs a bill into law. He files it in the Federal Register, and it consists of instructions to the executive branch about how they are to implement the new statutes created by a bill now that they're on the books. And where this becomes controversial is where a president uses a signing statement to instruct the executive branch that it will consider certain sections of this bill unconstitutional, so that they do not need to enforce the law as it is written. And where it becomes very controversial is when those sections that he's challenging are restrictions on his own authority, because then not enforcing the law really means not having to obey the law. And these previous presidents have done this, but it was exceedingly rare until the mid-1980s, when the Reagan administration legal team decided that they could start doing this more often as a way to increase presidential power. Sam Alito was part of that effort.
Explain why they thought the courts might look at this as sort of legislative history.
So the original idea was that activist courts were interpreting laws based on legislative history, that is the record of debate that Congress had when they were passing a law to sort of figure out what a law meant, and the judges were sort of picking and choosing what they wanted from that universe to support whatever their preferred policy version is.
Which is probably true, by the way, but anyway.
That's definitely that's one of Scalia's great crusades. He hates this stuff because it's so open to manipulation. Yeah. Well, as long as this is happening, we should at least get the president's views in there. So maybe when there's an ambiguous statute, the president should leave a record of his understanding of what it means, and if there's a dispute later, the court will look to that, and the president will have greater influence as the sort of final word over what the law will be interpreted to mean. And that turns out that never happened. Courts really just haven't looked at signing statements. But this tool became powerful in this other way of shaping how the executive branch was going to implement laws, and even not implementing those the president thought were unconstitutional. And so George H.W. Bush issued a bunch. Bill Clinton, a Democrat, also issued a bunch. But then the Bush-Cheney administration took this to a whole new exponential leap. And at this point, the count is over 1,000 bill sections, 1,000 laws that just in 6 years Bush challenged using signing statements, which is more than all previous presidents in American history combined. So this is dramatic. Even with the increase starting in the Reagan years, it is almost double all previous presidents in the history combined. And it includes the McCain torture ban, which this is unconstitutional because of my unwritten powers as commander-in-chief and because of the unitary executive theory. Oversight provisions that were added to the Patriot Act by Congress as a condition of making that law permanent. But also things that have nothing to do with national security. All kinds of affirmative action regulations, requirements to give reports to Congress about all kinds of things, just all over the map. Anything that requires the executive branch to do something or forbids it from doing something under the Bush legal theories is unconstitutional because the president has total control over government information, over the executive power.
This excerpt is brought to you by the Massachusetts School of Law, the leader of reform in legal education and a leader in multimedia education for the public. To view the full interview and for a full listing of MSL's programs, log on to mslaw.edu.